With Supreme Court Justice Anthony Kennedy retiring, there is a lot that is now potentially on the line, including abortion rights, unions, which were already attacked this week, and LGBTQ rights. Now, what I want to focus on in this video is just how ridiculous the Supreme Court Justice appointing process is. So, I want to compare the American system to the Canadian system. Now, before I do that, I want to share a couple tweets that summarize how I feel about this insane American system. So, Alex Koch tweeted out, 5 quote-unquote moderate senators from Alaska, Maine, West Virginia, Indiana, and North Dakota have the power to essentially decide whether women can control their own bodies for the next 40 years. Because of our political system, that definitely makes sense. And this tweet from Pixelated Boat, in hindsight, maybe it was a mistake for America to pick a legal system that depends on particular old people dying at the right time. Exactly. This American system is insane. And you can't really appreciate how nuts it is until you compare it to a system in another country like my country, Canada. So both Canada and the US have Supreme Courts. So we both have systems where multiple judges decide on cases and vote on the outcomes. But in Canada, the Supreme Court really doesn't have the mainstream press coverage that it does in the US. And I think a lot of that is because Canada's Supreme Court isn't as divisive. Now, why isn't the system as divisive as the one in the US? So I'm going to break this down. Now, this will give you some, I think, real perspective, if you're an American, real perspective on just how much power the president has and how much power they really shouldn't have. So let me break it down in terms of different areas here. So the number of judges, the qualifications, and how these judges are appointed. So first up, the number of judges. Now, in Canada, the Supreme Court consists of 1 Chief Justice and 8 Associate Judges. In the US, the court maximum is 9 judges, all of whom are entitled to 1 vote. One of these justices functions as the Chief Justice, much like the Canadian system. However, the court may function with less judges if one has left and hasn't yet been replaced. Now, so far there really isn't much of a difference, but now let's get to the qualifications needed to be a judge. And this is where we begin to see differences. So, in the US Constitution does not put any restrictions on who the president may appoint, but normally only sitting senior judges or highly respected jurists are appointed. In the current environment and the need for Senate confirmation of the appointment, the political palatability is a significant factor in the decision. Now, keep in mind that this article that I'm reading from was written during Obama's last year. So, while their assumption here is that palatability matters, under Trump and the GOP, palatability doesn't matter as much as it once did. Now, Trump will only really have to worry about people like Susan Collins, who, may vote against someone who wants to reverse abortion rights. But ultimately, Republicans vote as a whole, and they are very likely to appoint anyone that Donald Trump puts up. Now, compare this to Canada. So in Canada, these are the qualifications needed. In order to receive a nomination, a candidate must have been a member of a provincial or territorial law society for at least 10 years, or have served as a judge in a superior court. In addition, to ensure that the court has knowledge and experience with Quebec's civil law code, at least 3 Supreme Court judges must come from that province. Since a cross-section of judges from all provinces is desirable, it is a practice that the court includes at least 1 judge from Atlantic Canada, a minimum of 2 judges from Western Canada, and 3 judges from Ontario. So there are at least 2 main differences here. 1, in Canada, the judge has to actually be qualified. So in the US, Trump can essentially try and appoint anyone he wants. But in Canada, there are restrictions on experience. And there's also a desire to get judges from all over the country. So to have proper representation from people who live on the East Coast, on the West Coast, and somewhere in the middle. So those are some of the existing restrictions in terms of qualifications in Canada. But under Trudeau's government, he actually made some changes. So there is now more independent oversight into the process. So this from CanadaVersusAmerica.com. As opposed to the US, Canadian Parliament as a whole is not responsible for approving nominees, which removes some of the dog and pony show politics from the process. While it used to involve a confidential shortlist and private meeting between the PM, the Cabinet, and the Governor-General, who represents the Queen, Canada recently modified its judicial appointment process as part of Trudeau's efforts to make the process more diverse and transparent. The judicial appointment process is as follows, reflecting Trudeau's recent changes. 1. Judges from a superior court or members of the bar for more than 10 years may apply to become a Supreme Court justice. Applicants fill out a lengthy questionnaire that includes questions on their Indigenous status and sexual orientation. 2. An independent 7-member advisory board comprised of lawyers, judges, scholars, and non-legal members, recently chaired by former Prime Minister Kim Campbell, reviews applicants and submits a non-binding shortlist of 3 to 5 candidates. 3. Cabinet ministers, along with provinces and territories' Attorney General, several House of Commons committees, and Canada's Chief Justice review the shortlist. 4. The Prime Minister nominates a candidate from the shortlist. And 5. Members of Parliament and senators from various parties interview the nominee via an official Q&A before they are officially appointed and sworn in. Now, this whole approval process in Canada prevents the Prime Minister from inserting their own ideology into the pick. So they are given a short list of picks that are discussed and decided among a group of 7 people who have all different backgrounds, all different experiences, and they're the ones that then give that list to the PM to choose from. So right away, that narrows down the power that the Prime Minister has in choosing who the Supreme Court justice pick will be. Now, compare that to the US, where it's really luck of the draw. So if you happen to be a conservative president during a time where, half the bench is old and near retirement age, then you may get lucky and have some of them retire or die and be able to choose now new, younger conservatives to pack that bench for the next 30, 40 years. So the process in Canada avoids that all that bullshit that occurs right now, or that's happening right now in the US. Now, there is something else I want to mention here. So the mandatory in Canada, the Supreme Court has a mandatory retirement age of 75. So again, this helps having to worry about a Supreme Court justice dying while on the bench. There is already this built-in knowledge that whoever gets picked is going to have to retire at 75. So you're always sort of aware when there will be a pick down the line. And again, that pick, it isn't as politicized as it is in the US because of the qualifications and the approval process that is built in. So it's all just luck. It's all just who's president at the time when these people are old and dying and retiring, and who isn't. And that just doesn't make any sense. Now, I wish I had some solutions for you. I don't know how the US could ever get to a place where they would, analyze this process and potentially change how this works. But I just want to give you some. I just wanted to give you some perspective on how it works in Canada, and really show you just how insane the American system is. Hey, if you like this video, hit that subscribe button below and consider throwing me a few bucks on Patreon at patreon.com/therationalnational or therationalnational.com/join.